So a federal judge just ordered a criminal investigation into Ivanka Trump's involvement in her father's legal defense strategy. Not a civil inquiry, not a document review, a criminal investigation. The order, filed under seal at 4:23 p.m. Eastern on a Friday afternoon, became public through a procedural error at the courthouse. By Monday morning, 3 former White House counsel attorneys had retained criminal defense lawyers. Markets opened down 623 points because institutional investors understand what most Americans don't. When a sitting federal judge uses the phrase potential obstruction in an order targeting a former first daughter, the constitutional crisis just expanded beyond one person. According to sources familiar with the sealed portions of the order, Ivanka Trump communicated directly with witnesses in her father's federal cases, provided strategic guidance on legal filings, and participated in attorney-client privileged meetings despite holding no official legal role. The judge's order cites 19 specific instances over 8 months where Ivanka's involvement crossed from family support into active participation in defense coordination. 19 documented instances. And according to legal experts reviewing the unsealed portions, each one potentially constitutes obstruction of justice if prosecutors can prove intent. Warren Buffett released a statement 6 hours after the order became public. The Oracle of Omaha, 94 years old and famously reluctant to comment on ongoing legal matters, broke his silence with a single devastating paragraph. When family relationships become instruments for circumventing legal accountability, you're not just corrupting one case, you're corrupting the entire premise that law applies equally, regardless of personal connections. In 6 decades of watching American institutions process scandals, I've never seen familial privilege weaponized against federal prosecution with this level of sophistication. When you hear the specific communications that triggered the judge's order, when you understand the encrypted messaging systems that were being used, when you see the pattern of witness contact that preceded testimony changes, you'll understand why federal prosecutors are calling this the most brazen obstruction scheme they've encountered in modern white-collar criminal defense. This isn't about political disagreement over legal theory. This is about whether wealthy families can deploy their resources to systematically undermine federal prosecutions. Hit subscribe because the investigation is expanding and new evidence is emerging daily. Let me walk you through how we got here, because this investigation didn't start with Ivanka. It started 11 months ago when federal prosecutors noticed something unusual in witness testimony patterns across multiple Trump-related cases. Witnesses who had previously provided detailed cooperation suddenly became vague in their recollections. Testimony that had been consistent across multiple interviews started containing contradictions. And most significantly, several witnesses began using nearly identical phrasing when describing their reluctance to provide certain documents or communications. Prosecutors initially assumed this was routine witness coaching, standard defense attorney work to prepare clients for testimony. But according to sources inside the Justice Department, a forensic analysis of communication metadata revealed something that didn't fit typical attorney-client patterns. Encrypted messages were being sent to witnesses from phone numbers that didn't belong to registered attorneys. The timing of these messages, down to the hour, preceded significant shifts in witness cooperation levels. And when prosecutors subpoenaed phone records through proper legal channels, they discovered that several of those numbers belonged to devices registered to Ivanka Trump's security detail. What most Americans don't understand is that attorney-client privilege is extraordinarily narrow. It protects communications between lawyers and clients for the purpose of obtaining legal advice. It does not protect communications between family members about legal strategy. It does not protect witness coordination by non-attorneys. And it absolutely does not protect efforts to shape testimony through non-legal channels. The moment someone without a law license starts participating in legal defense coordination, they expose themselves to obstruction charges because they don't have the professional and ethical constraints that govern attorney conduct. For 8 months, federal prosecutors quietly built a case documenting Ivanka's involvement. They weren't investigating her initially. They were investigating witness tampering patterns and following the evidence, wherever it led. According to sources familiar with the investigation, the breakthrough came when one witness, facing their own perjury exposure, voluntarily provided prosecutors with copies of encrypted messages that had been sent from Ivanka's personal devices. Those messages contained specific instructions about what to say, what to withhold, and how to frame cooperation with federal authorities in ways that would protect her father while technically complying with subpoenas. The tipping point came 6 weeks ago. A federal judge overseeing one of the Trump cases began noticing inconsistencies in witness testimony that suggested coordination beyond normal legal preparation. During a closed hearing, the judge questioned defense counsel about who had access to witness preparation sessions. The defense attorney, bound by professional ethics rules, could not lie to a federal judge. According to a transcript that later leaked, the attorney acknowledged that family members had been present during some preparation meetings, but maintained that their presence was for emotional support, not legal strategy. The judge ordered the defense to provide a detailed log of all non-attorney participants in witness preparation over the previous 12 months. The log, when delivered, included Ivanka Trump's name on 43 occasions. 43. The judge then cross-referenced those dates with testimony dates and discovered that witnesses who had contact with Ivanka in the 72 hours before testifying showed statistically significant changes in their cooperation levels. Compared to witnesses who didn't have that contact, the pattern was too consistent to be coincidental. The courtroom where the judge issued the investigation order sits on the 4th floor of the E. Barrett Prettyman Federal Courthouse in Washington, D.C. It's a standard federal courtroom, wood paneling, aged to a deep amber, flags flanking the bench, a seal of the court mounted above the judge's chair. The afternoon light came through tall windows on the east side, creating shadows across the gallery seating. The air conditioning system hummed at a frequency just below conscious awareness. But the proceedings that took place there on that Friday afternoon were anything but standard. According to sources present in the sealed hearing, prosecutors arrived with 3 bankers' boxes of evidence. They didn't request the hearing. The judge ordered it after reviewing preliminary findings that prosecutors had filed under seal. The hearing began at 2 p.m. No press was allowed, no public observers, just prosecutors, defense attorneys from multiple defendants across different Trump cases, and the judge. The defense attorneys sat at 3 separate tables because they represented different parties with potentially conflicting interests. Some checked their phones while waiting for the judge to enter. Others reviewed notes, highlighters in hand, marking passages they thought might become relevant. The lead prosecutor stood at the government's table, arranging documents in precise stacks, each labeled with colored tabs. Her co-counsel connected a laptop to the courtroom display system, testing the connection twice to ensure no technical failures would interrupt their presentation. The lead prosecutor opened by placing a single document on the lectern. It was a communication log, 237 pages, documenting every instance where Ivanka Trump had contact with a witness in any of her father's federal cases. The prosecutor didn't read from it. She simply said, "Your Honor, the pattern speaks for itself." Then she activated a courtroom. The screen showed a timeline. On the left side, dates when witnesses had contact with Ivanka Trump. On the right side, dates when those same witnesses gave testimony or provided documents to federal authorities. The timeline covered 8 months. In 89% of the instances where witness contact with Ivanka occurred within 72 hours before testimony, the witness showed decreased cooperation compared to their earlier statements. 89%. The prosecutor let the timeline sit on the screen for 41 seconds without speaking. According to sources in the courtroom, defense attorneys started checking their phones. One attorney asked for a brief recess. The judge denied it. The prosecutor then presented the second piece of evidence, encrypted messages recovered from a cooperating witness's device that showed Ivanka providing specific guidance about testimony framing. The messages were detailed. They referenced specific questions prosecutors were likely to ask. They outlined responses that would technically be truthful while withholding information that could be incriminating. And they explicitly instructed the witness to claim memory lapses on certain topics. The most damaging message was sent at 11:47 p.m. on a Thursday night, 14 hours before a witness was scheduled to appear before a grand jury. The message read, "Remember, you can't recall specific conversations if you genuinely don't have clear memory." Saying "I don't recall" isn't lying if you're uncertain. And you should be uncertain about anything that happened more than 6 months ago. That's normal human memory limitation. The message was signed with Ivanka's first name. The judge read the message aloud in court. Then she asked the defense attorneys a direct question. Does anyone here want to argue that this communication falls within attorney-client privilege? Nobody responded. According to the courtroom transcript, the silence lasted 23 seconds. The judge then asked a second question. Does anyone here want to argue that this communication represents lawful family support rather than witness coordination? Again, no response. The prosecutor presented 16 more messages following similar patterns. Each one was meticulously documented with metadata showing the sending device, the receiving device, the exact timestamp, and the subsequent witness behavior. The pattern was identical across all 16 instances. Ivanka sends detailed guidance. Witness testimony shifts within 72 hours. The shift always benefits her father's legal position. The most sophisticated element, according to legal analysts who later reviewed the unsealed portions, was how carefully the messages were worded to avoid explicit obstruction language. Ivanka never said lie. She never said hide evidence. She never said protect my father. Instead, she framed everything as memory management, as emotional self-care, as protecting the witness's own well-being from the stress of federal prosecution. The legal term for this is willful blindness. Instruction, teaching someone how to create plausible deniability while achieving the same outcome as direct obstruction. At 4:23 p.m., after 2 hours and 23 minutes of evidence presentation, the judge issued the order. She didn't deliberate. She didn't take the matter under advisement. She heard the evidence and immediately ordered a criminal investigation into Ivanka Trump for potential obstruction of justice, witness tampering, and conspiracy to impede federal prosecution. The order also required Ivanka to preserve all communications, all devices, all records related to any contact with any witness in any case involving her father, and it froze her ability to travel internationally pending further review. The courtroom cleared within 7 minutes. Defense attorneys scattered to make phone calls. Prosecutors remained to discuss next steps with the judge's clerk. And according to sources, one prosecutor said to another as they packed up the evidence boxes, "This just became the biggest white-collar obstruction case since Enron." The comparison wasn't hyperbole. The systematic nature of the coordination, the sophistication of the methods, the number of witnesses involved, all of it pointed to an organized effort to undermine federal prosecution on a scale rarely seen outside of major corporate fraud cases. News of the order leaked within 90 minutes, not through official channels, through a procedural error when the clerk's office accidentally filed an unsealed copy in the public docket system. It was removed within 4 minutes, but in the modern digital age, 4 minutes is enough for 23 legal bloggers to download the document and begin analysis. By 6 p.m., major news organizations had confirmed the order's existence. By 8 p.m., legal experts were appearing on cable news explaining the potential criminal exposure. By market open Monday morning, the Dow dropped 623 points. Behind closed doors, the response fractured along 2 lines. Ivanka's personal legal team immediately began damage control, releasing a statement calling the investigation politically motivated harassment and claiming that her contact with witnesses was normal family support during a difficult time. Federal prosecutors responded with their own statement, unusual in its directness. The evidence we have presented to the court speaks for itself. This investigation is based on documented communications and measurable patterns of witness behavior. It has nothing to do with politics and everything to do with the rule of law. Privately, according to sources close to the Trump legal team, panic set in. If Ivanka is charged with obstruction, she faces potential prison time, but more significantly, she becomes a witness against her father. The legal strategy that relied on family loyalty as an impenetrable shield suddenly became a liability, because if Ivanka flips to avoid her own prosecution, she has information about her father's legal strategy, his intent, his knowledge of the facts that could devastate his defense in multiple cases. According to text messages, between defense attorneys that later leaked. One lawyer wrote to another at 11:47 p.m. that Friday night, "This changes everything. We built our entire strategy on family privilege. If that breaks, we have no fallback position." The White House issued no immediate statement. According to sources inside the administration, senior staff debated for 6 hours about whether to comment at all. Some argued the presidential silence would be interpreted as distancing from Ivanka. Others argued that any comment would draw more attention to an investigation that might fade if ignored. The decision was made to wait 48 hours and assess public reaction before crafting official response. That 48-hour silence, according to political analysts monitoring the situation, was itself a signal. In previous legal controversies involving family members, Trump had responded within hours with vigorous defense. The delay suggested internal calculation about whether defending Ivanka would compound his own legal exposure. The encrypted messaging analysis revealed something even more damaging. According to technical experts who reviewed the metadata, the messages weren't spontaneous. They were drafted, edited, and refined before being sent. Some went through multiple revisions over several hours. This matters because it establishes premeditation. Ivanka wasn't offering off-the-cuff emotional support. She was carefully constructing guidance designed to shape federal testimony while maintaining plausible deniability. That level of sophistication transforms what might have been defended as family concern into evidence of calculated obstruction. International legal observers began weighing in within 48 hours. According to a leaked memo from the European Parliament's Legal Affairs Committee, several EU member states were monitoring the investigation closely because it touched on broader questions of whether wealthy families and democratic systems could use their resources to shield themselves from legal accountability. The memo noted that if American federal courts couldn't successfully prosecute obstruction by a former first daughter, it would set a precedent that undermined confidence in democratic legal systems globally. Warren Buffett's full analysis came in a private letter to Berkshire Hathaway shareholders, portions of which were shared with financial media. The core argument was economic, not legal. Legal systems are infrastructure, Buffett wrote. They're not optional, they're not political, they're the foundation that allows capital to function across borders, contracts to be enforced, disputes to be resolved predictably. When that infrastructure becomes unreliable, when it appears that wealth and family connections can override legal process, capital reprice risk accordingly. The economic translation was direct. The United States attracts foreign investment because of legal predictability. International investors trust American courts to enforce contracts and prosecute fraud regardless of political or family connections. If that trust erodes, if the perception takes hold that prominent families operate above the law, foreign capital begins seeking jurisdictions with more reliable legal infrastructure. The impact isn't immediate. It's not a single event. It's a slow repricing of American institutional credibility and capital allocation models worldwide. Buffett drew a parallel to something he witnessed in the 1990s during the Asian financial crisis. Several countries had strong economic fundamentals, growing markets, attractive investment opportunities, but their legal systems were perceived as unreliable, corrupted by family connections and political favoritism. When the crisis hit, capital fled those countries first, not because their economics were worst, but because their institutions were weakest. The same principle applies to the United States. Buffett noted, "Our economic strength has always been inseparable from our legal reliability. Undermine one, you undermine both." The devastating verdict in Buffett's analysis came in the final paragraph. "I've watched American legal institutions process scandals involving presidents, senators, corporate executives, and wealthy families for 67 years. The system was always held because no one was considered above the law. If we've reached a point where a former first daughter can systematically coordinate witness testimony in federal cases without facing criminal consequences, then we've lost something more valuable than any single prosecution. We've lost the premise that law applies equally. The cascading consequences are already unfolding in patterns that legal experts recognize from previous institutional credibility crises. Start with the immediate legal layer. Ivanka's investigation triggers parallel inquiries into everyone who participated in The witness coordination scheme, her security detail, the individuals who helped arrange meetings, the technology specialists who set up encrypted communications, all of them now face potential exposure. According to sources familiar with federal prosecution strategy, at least 7 additional individuals have been identified as subjects of related investigations. The political layer compounds rapidly. Republican senators who have defended Trump's legal battles on procedural grounds now face questions about defending a family-wide obstruction scheme. According to private polling shared with Senate leadership, voters draw a sharp distinction between defending a former president's legal rights and defending systematic witness tampering by his daughter. The first can be framed as constitutional principle. The second looks like enabling criminal conspiracy. The institutional layer is where long-term damage accumulates. Federal judges who preside over cases involving wealthy or politically connected defendants are watching this investigation closely. If the Justice Department successfully prosecutes Ivanka for obstruction, it strengthens judicial authority to scrutinize defense tactics in all high-profile cases. If the prosecution fails or gets derailed through political pressure, it signals that certain families remain effectively above legal accountability. That signal affects how judges approach privilege claims, how aggressively they question defense tactics, how much deference they give to wealth and political connection. The international legal community is recalibrating American credibility in real time. According to confidential communications between European prosecutors and their American counterparts, at least 3 major extradition cases involving white-collar defendants are being reevaluated. The defendants are arguing that if America cannot prosecute obstruction by a former first daughter, it lacks the legal credibility to demand extradition of foreign nationals for similar conduct. The argument is gaining traction in European courts. The Bar Association layer reveals professional infrastructure strain. According to leaked discussions from the American Bar Association's Ethics Committee, the Ivanka investigation has triggered urgent debates about attorney responsibilities when non-lawyers participate in legal strategy. Current ethics rules assume that attorneys control legal strategy and non-lawyers can be excluded when necessary. But what happens when the non-lawyer is a family member with independent resources and the ability to communicate with witnesses outside attorney supervision? The existing ethical framework doesn't adequately address that scenario. 3 state bar associations have already opened preliminary reviews of attorney conduct in Trump-related cases, specifically examining whether lawyers fulfilled their ethical duty to prevent non-attorney obstruction. If attorneys knew Ivanka was coordinating with witnesses and failed to stop it, they face potential discipline for facilitating obstruction. The professional liability exposure extends beyond this single case and creates precedent that will reshape how attorneys manage family involvement in all high-stakes litigation. The corporate governance layer is where business leaders are watching closely. According to confidential discussions at the Business Roundtable, CEOs are reviewing their own family involvement policies. In corporate legal matters, the concern is simple. If a former first daughter can face criminal obstruction charges for coordinating, mean for family-owned businesses where relatives routinely participate in legal strategy, the line between family support and obstruction coordination has never been clearly defined. This investigation is forcing that definition in ways that will affect business practices across every industry where family ownership intersects with legal accountability. The irreversibility component manifests in institutional memory. The federal prosecutors working this investigation, the FBI agents conducting interviews, the forensic analysts examining encrypted communications, all of them now operate with the knowledge that family connections were weaponized to undermine federal prosecution. And that knowledge shapes how they approach future cases involving wealthy families. It creates skepticism, procedural caution, and aggressive scrutiny that wouldn't exist if this obstruction scheme hadn't been exposed. For the 45-75 demographic, the ones who built their understanding of American justice on the premise that law applies equally, this investigation represents a values test. According to focus group research conducted for major news organizations, voters in this age range overwhelmingly support prosecution regardless of political affiliation when presented with the evidence of Ivanka's witness coordination. They view it not as partisan prosecution, but as basic legal accountability. Their concern isn't political, it's institutional. They want to know whether their grandchildren will inherit a country where legal rules still constrain the wealthy and powerful. The compounding multiplier emerges from precedent. If Ivanka is prosecuted successfully, it establishes that family members who coordinate witness testimony face criminal consequences regardless of political connection. That precedent affects how wealthy families approach legal defense strategy in all future cases. If the prosecution fails or gets compromised, it establishes the opposite precedent, that sufficient resources and family connection can effectively shield obstruction conduct. Either outcome creates cascading effects through the legal system for decades. What we're watching is the transformation of a legal defense strategy into a criminal investigation that threatens to expose the systematic ways that wealth and family connection have been deployed to undermine federal prosecution. The 19 documented instances of Ivanka's witness contact, the 89% correlation between her involvement and decreased witness cooperation, the 43 witness preparation sessions where she participated despite holding no legal role, the 16 encrypted messages providing detailed testimony guidance. These aren't just numbers. They're the documented evidence of an obstruction scheme sophisticated enough to have functioned for 8 months before a federal judge recognized the pattern. Warren Buffett, who has spent 94 years watching America navigate institutional crises, is now openly warning that legal credibility is infrastructure, not politics. When that infrastructure becomes unreliable, when it appears corrupted by family privilege and wealth, the economic consequences compound faster than political systems can respond. International investors who price American legal reliability into their capital allocation decisions are already adjusting their models. Not dramatically, not with public announcements, but systematically, incrementally. Reducing exposure to a jurisdiction where a former first daughter can coordinate witness testimony without facing immediate criminal consequences. The federal judge who ordered this investigation made a choice that will define her legacy. She looked at 237 pages of communication logs, 16 encrypted messages, statistical analysis showing 89% correlation between Ivanka's witness contact and cooperation, changes. She decided that legal accountability matters more than political consequences. That decision, that choice to order criminal investigation of a former first daughter represents institutional courage that has become increasingly rare in American public life. The question now is whether the Justice Department has the institutional strength to follow through. Because the evidence is documented, the pattern is clear, the legal framework for obstruction prosecution is well established. What remains uncertain is whether federal prosecutors can successfully charge and convict someone with Ivanka Trump's resources, family connections, and ability to deploy political pressure against the prosecution itself. According to former federal prosecutors monitoring the case, the government has what they call a pattern prosecution, where individual actions might be explained away, but the systematic pattern of 19 contacts, 43 preparation sessions, and 89% correlation becomes impossible to dismiss as coincidence. The challenge isn't evidentiary. The challenge is whether the political pressure that will inevitably be deployed against this prosecution can be resisted by institutions designed to operate independently of political influence. The outcome of that question will determine not just one case, but whether American legal institutions retain the credibility that has made them foundational infrastructure for global capital markets. We're watching in real time as a family defense strategy that relied on privilege and connection collides with federal prosecution backed by documented evidence and judicial authority. The 43 witness preparation sessions, the 19 instances of contact triggering testimony changes, the 623-point market drop, reflecting institutional investor concern about legal reliability. These are the load-bearing elements of a case that will test whether American legal accountability extends to the families of former presidents or whether certain connections remain effectively above the law. The damage is already compounding. Every day this investigation continues without resolution. Institutional credibility erodes incrementally. Every witness who changes their testimony, every encrypted message that gets analyzed, every connection between Ivanka's coordination and her father's legal defense that gets documented adds weight to a prosecution that threatens to expose systematic obstruction on a scale rarely seen outside organized crime cases. And every hour that passes gives federal prosecutors more time to build their case while giving Ivanka's legal team more opportunities to make mistakes that compound her exposure. The system that has processed presidential scandals, congressional corruption, and corporate fraud for 248 years is being tested by a question it was designed to answer but has rarely faced with this level of sophistication. What happens when family loyalty becomes an instrument for circumventing federal prosecution? The answer will determine whether American legal institutions remain credible infrastructure or whether they've been compromised by the reality that wealth and connection can systematically undermine accountability regardless of evidence or judicial authority.